this is Dr. Perry Carpenter. I'd like to thank you for taking the time to join me on this week's video. On this week's video, we're in part 7 of our new 10-part series entitled the QME Top 10. And in this series, we're discussing the most pressing issues, concerns, confusions, and frustrations that qualified medical evaluators are facing. And in today's discussion, I want to share with you some ideas, some information, and some landmark cases that directly relate to the day-to-day opinions and conclusions that you're providing in your QME reports. You know, I get a lot of calls from doctors on a daily basis asking for consultation regarding the QME evaluations that they're performing. And many times doctors will ask me, well, Dr. Carpenter, how would you go in this case? Or how do you think I should opine in this case? Or what do you think this case needs? And I tell the doctors a story. And I want to share that story with you. And this is a story that an applicant attorney shared with me almost probably a decade ago. And I remember it as if it was yesterday. I was playing golf with an applicant attorney, and we were discussing issues related to the qualified medical evaluation. And I was posing to him many of the same questions that doctors today are posing to me. And the applicant attorney asked me, he said, Perry, have you ever heard of the story of the 3 umpires? I said, no, I don't think so. And he said, well, I want to tell you a story. It's called The Story of 3 Umpires. And he said, this story was told to me. He said that. He said, this story was told to me by one of my professors in law college, and I want to share it with you. So I said, okay, great, so let's hear it. He says, okay, this is the story of 3 umpires. Well, one day a reporter interviewed 3 umpires to ask the umpires about how they go about making their decisions. When is the pitch a ball? When is the pitch a strike? When is the runner safe at first? And when is the runner out at first? How do you make your decisions? The reporter asked this question to 3 umpires. And the first umpire gruffly replied, I calls them as I sees them. And the second umpire said, I call it like it is. And the third umpire said, it ain't nothing until I call it. It ain't nothing until I call it. Meaning, it's not a ball, it's not a strike, until he calls it such. He's the one that makes the call, that makes it happen, that makes the play, that ultimately makes the game. The umpire has the authority to make the call. So how does that relate to the work that we do? We as qualified medical evaluators have a great deal of authority to make a great deal and a great number of calls that affect the direction of the case. We make the call. There is no case until we make the call. We have the authority to make the call. And so I tell the doctors over the telephone, you have the authority to make the call. Which way do you see this case going? What's your gut feeling? What's your opinion? Make the call. And the point of today's discussion is that you make the call. I want to share with you in today's discussion some philosophy about the authority that we have to make the call. We can make the call left, we can make the call right, we can provide for permanent and stationary, we can provide for additional care, we can be applicant oriented, we can be defense oriented, we can take the case in any direction we want. We have the authority to make the call. I want to share with you some landmark cases that came through our system over the past decade that gave us and gives us the ongoing authority to make the calls. Now, there's one caveat here, and that is, while we do have the authority to direct the direction of the case, our opinions and conclusions are only valid opinions and conclusions when they qualify as substantial medical evidence. And what I want to share with you today is some information, number one, that reviews and supports our authority to make the call. And number two, I want to share with you some cases that show what can happen when doctors provide opinions and conclusions that do indeed qualify as substantial medical evidence. And then on the other hand, I want to show you what can happen when doctors' opinions and conclusions are not substantial, how those types of opinions are not upheld, while opinions and conclusions that are substantial will be upheld. So we're going to review very quickly here today 5 landmark cases that give us authority to make the call, as long as those calls qualify as substantial medical evidence. Now, in preparation for today's discussion, I sent you these 5 cases as live links in today's blogcast. So I want you to go ahead and print out those cases so that we can review those together and lay our eyeballs on the same material as we go through this discussion. And then also I want you to go ahead and get your AMA guides, turn to chapter 17 to the section on gait derangement, because we're going to go through one example that reviews permanent impairments related to gait derangements. So I'll give you a minute to go ahead and get those references, and I look forward to being back with you here in just a moment as we continue with our 10-part series on the QME Top 10. And today we're specifically in part 7, which is entitled, You Make the Call. Okay, I'm back with you now, and I have my references all printed out, and I have my AMA guides here with me, and I hope you have these references printed out as well. It'll be really helpful if you can lay your own eyes on these passages as we go through them. So I want to review with you today 5 landmark cases that dramatically affect the work that we do as qualified medical evaluators. And the first case I want to review with you is the Escobedo case. Now, throughout this series, the QME Top 10, I have made many mentions to the Escobedo case, and I just want to touch very briefly upon it here as it relates to today's discussion. But let me just say that the Escobedo case is a landmark case that gives us so much direction, especially as it relates to our opinions and conclusions on apportionment of the permanent impairment. But in addition to that, it gives us so much direction for fashioning all of the opinions and conclusions in our report in such a way that they basically become irrefutable. And that's what you want your opinions and conclusions to be when you ultimately provide them. You want them to be irrefutable. I frequently tell doctors to not be necessarily an advocate either for or against the injured worker, but on the other hand, to be an advocate for your opinions and conclusions, to defend your opinions and conclusions, whatever they may be. We don't defend the applicant, we defend our opinions and our conclusions. And so the Escobedo case just has so much rich philosophy that relates directly to our day-to-day work. But as relates to today's discussion, I just want to share a couple of passages with you. And this has to do with the concept of substantial medical evidence, which we've discussed before. Now, in order for your opinions and conclusions, whatever those opinions and conclusions are, in order for those opinions and conclusions to be upheld, meaning to be followed by the parties, your opinions and conclusions have to meet certain criteria. The opinions and conclusions have to qualify as what's referred to as substantial medical evidence. And the Escobedo case tells us exactly what those criteria are. So once we know what the criteria are, we simply follow the recipe as it's described in Escobedo in fashioning our opinions and conclusions. And if we can follow the recipe, if our opinions and conclusions can actually follow the recipe and meet every criteria in the recipe, those opinions and conclusions will be upheld. They will be seen as irrefutable conclusions. Okay? So let's review some of these criteria from the Escobedo case. Now, the first thing that's important to understand is that if you do not support your opinions and conclusions, if you do not explain your opinions and conclusions, if you do not reveal the reasoning behind your opinions and conclusion, your opinion and conclusion doesn't mean anything. It's simply referred to as a conclusory opinion. The opposite of a conclusory opinion is a substantial opinion, and we're working here in this discussion on making our opinions and conclusions substantial. Okay? So let me give you a little philosophy on that. It says here that a medical report is not substantial evidence unless it sets forth the reasoning behind the physician's opinion, not merely his or her conclusions. And in speaking with doctors on the phone on a daily basis, many doctors have in mind some pre-established opinions and conclusions. They have in mind a direction that they want to take the claim. And when I ask those doctors to provide for me their reasoning behind the opinion and conclusion, whatever the opinion and conclusion is, and I ask them to give me their reasoning behind that opinion or conclusion, many times the other end of the phone becomes silent. And doctors are unable to provide support, are unable to provide reasons, are unable to provide the rationale and the reasoning that went into the opinion or conclusion. And I tell them that that opinion is not going to be upheld. Many times doctors will tell me, well, let's just wait and see. Let me just put the opinion down and see what happens. And I simply agree with them to do that. But that's not how I produce my own reports. In my own reports, and the way I'm encouraging you to fashion your reports, is to provide the how and why reasoning behind every opinion and conclusion that you offer. Every opinion and conclusion that you offer should be supported with a bullet point list of reasons. Okay? It tells us so right here in Escobedo. It says, a mere legal conclusion does not furnish a basis for a finding. In other words, an opinion that fails to disclose its underlying basis and gives a bare legal conclusion does not constitute substantial evidence. Further, the chief value of an expert's testimony, which is us, we're experts, the chief value of our testimony rests upon the material from which his or her opinion is fashioned, and the reasoning by which he or she progresses from the material to the conclusion. And it does not lie in the mere expression of the conclusion. Thus, the opinion of an expert is no better than the reasons upon which it is based. So always provide your reasons behind every opinion or conclusion. Okay, so that's the philosophy. In order for your opinion and conclusion to qualify as substantial, it must provide the reasons. So that's one component of the recipe for substantial medical evidence. Let me give you a couple of the other components, and then we can move on to some other cases that illustrate these principles. Okay? Therefore, to be substantial medical evidence, in this case on the issue of apportionment, okay? But this applies to all of your opinions and conclusions. To be substantial evidence, a medical opinion must be framed in terms of reasonable medical probability. Let's just think about this for a second. It must be framed in terms of reasonable medical probability. Therefore, when you provide your opinion or conclusion, always frame it in terms of reasonable medical probability. What does that sound like in the body of your report, or how does that look in the body of your report? It looks simply as follows. In my opinion, comma, within reasonable medical probability, comma, 60% of the permanent impairment is due to the industrial injury, and 40% is due to blah, 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 whatever the remaining text is. But you see how I inserted the phrase reasonable medical probability in the context of the opinion. So it must be framed in terms of reasonable medical probability. It must not be speculative. It must be based on pertinent facts and on an adequate examination and history. And, as we said before, it must set forth reasoning in support of its conclusions. For example, if a physician opines that approximately 50% of an employee's back disability is directly caused by the industrial injury, the physician must explain how and why the disability is causally related to the industrial injury. So you have to explain it. Makes sense, right? Can't simply say 50% is due to the industrial injury. You have to explain how and why. For example, an explanation could include the industrial injury resulted in surgery, which caused vulnerability that necessitates certain work restrictions. That would be an example of an explanation. Okay, so that's the prescription for substantial medical evidence. If you can provide opinions and conclusions that meet the criteria of substantial medical evidence, they will be upheld almost without exception every single time. And let me give you a couple of examples where the qualified or agreed medical evaluator provided opinions that qualified as substantial, and an example where the evaluator provided an opinion, but it was found to be not substantial and it was not upheld. Okay? So I want to share with you the Cannon versus City of Sacramento case. And we referred to this in this series a couple of sessions ago related to subjective and objective examination findings. So just a little background on the Cannon case. Cannon was a police officer in the city of Sacramento, and as a result of being on his feet for extended periods of time, developed plantar fasciitis. Well, he received treatment for about 15 months, including physical therapy, an injection, and custom shoe orthotics. Well, when he was declared to be permanent and stationary, the primary treating physician found no permanent impairment because Mr. Cannon had a normal physical exam, he'd returned back to work, and also because Chapter 17, the lower extremity chapter, really does not provide for any permanent impairment for a condition like plantar fasciitis. Well, Mr. Cannon disputed that, and he was ultimately evaluated by an agreed medical evaluator who was a podiatrist, I believe. And on first examination, the podiatrist opined similarly to the primary treating physician, and he found no impairment. Well, the applicant attorney requested a reconsideration under Alvarez and Guzman II decisions, and inquired as to whether or not possibly an alternative type of permanent impairment could describe Mr. Cannon's ongoing condition. Well, the agreed medical evaluator thought about it, and he explained that Mr. Cannon's ongoing condition could possibly be considered to be equivalent to a limp with arthritis. Now, a limp with arthritis is described in Chapter 17 under the gait derangement section. So the agreed medical evaluator opined that perhaps Mr. Cannon's condition was similar to a limp with arthritis. Now, Mr. Cannon did not have a limp on physical exam. Mr. Cannon did not have arthritis of any of the joints of the involved foot. But the agreed medical evaluator opined that because Mr. Cannon's plantar fasciitis could cause him some difficulties with prolonged weight-bearing activities, such as distance running, that it was similar to a limp, which would also cause problems with prolonged weight bearing. That was the only similarity between Mr. Cannon's condition and the analogous permanent impairment described in Chapter 17 under the gait derangement chapter. Well, the permanent impairment for limp with arthritis is 7%. So ultimately, Mr. Cannon received a 7% permanent impairment award based upon an analogous permanent impairment under Alvarez and Guzman 2 that the AME provided. Now, what's interesting about this is that this permanent impairment rating, which to me seems to be preposterous, seems to be absolutely preposterous. The primary treating physician found no impairment. The agreed medical evaluator on first evaluation found no impairment. And Mr. Cannon ended up with 7% whole person impairment on reconsideration by analogy to a limp with arthritis. Okay? Now, if you have an actual limp, let's just explore this for a minute. In my opinion, I said this is a preposterous permanent impairment rating. But it was upheld. And what makes it preposterous? Well, what makes it preposterous is if you have an actual limp and you're actually qualified for permanent impairment under the gait derangement section of Chapter 17, you have to demonstrate that you have an antalgic limp with a shortened stance phase and, not or, and documented moderate to advanced arthritic changes, of the hip, knee, or ankle. Now, Mr. Cannon did not have a limp. Okay? So, the analogy to this description under gait derangement was liberalized because he didn't have a limp. So the description was liberalized one time for Mr. Cannon by analogy. Secondly, in addition to an antalgic limp, in order to qualify for gait derangement, permanent impairment under gait derangement, a person with an actual limp has to demonstrate moderate to advanced arthritic changes of the hip, knee, or ankle. In other words, there has to be positive, objective diagnostic imaging findings. A fairly tall criteria, would you agree? Fairly tall criteria have to have a limp, a permanent limp, with documented objective findings on diagnostic imaging studies. Mr. Cannon had no signs of arthritis on diagnostic imaging findings. So the analogy, the description of the permanent impairment, was again liberalized in favor of Mr. Cannon. So the analogy was liberalized twice. I don't know if that's a doubling of the liberalization or a square function, but the description was generously liberalized for an examinee who had otherwise a totally normal physical exam. In my opinion, this is an extremely generous permanent impairment rating for a person who basically has no permanent impairment. But the point of this discussion is that on appeal, the appeals board, the judge, the workers' compensation judge, upheld the permanent impairment rating of 7%, which to me seems preposterous. But the reason that it was upheld was because he found that the agreed medical evaluator's opinion qualified as substantial medical evidence. And let me just locate that reference. The report should explain its impairment conclusions. In other words, a physician's whole person impairment opinion must constitute substantial evidence upon which the workers' compensation appeals board may properly rely. Includes setting forth the reasoning behind the assessment. Okay, so what did the judge say about the AME's assessment? Okay, reference to that in this discussion. says that it is undisputed that Cannon's condition, which is plantar fasciitis, is manifested only by his subjective experience of pain. Thus, his condition appears to fall right into the category of cases the 6th District was describing in Milpitas Unified, where the AMA guides, quote, calls for the physician's exercise of clinical judgment to assess the impairment most accurately. The agreed medical evaluator used his clinical judgment. He didn't use the AMA guides. Plantar fasciitis is not described in the AMA guides. Dr. AME performed that assessment here and determined that Cannon's plantar fasciitis resulted in a 7% whole person impairment, equivalent to a limp with arthritis. The city has shown no error in that assessment and no error in the board's decision based on that assessment. And as I said earlier, if you can follow the recipe and construct your opinions so that they qualify as substantial medical evidence, they basically will be irrefutable. And in this case, the city of Sacramento was unable to refute the analogous permanent impairment. So this illustrates the point that you make the call. You can make the call. You can liberalize these permanent impairment descriptions once, twice, 3 times. The sky's the limit. You can do whatever you want, as long as your opinion and conclusion is substantial. It will be upheld. Therein lies the challenge. The challenge is not in providing the opinion or conclusion. The challenge rests in making your opinion and conclusion substantial. Okay? Now I want to go on to another case. This is the Sherman case, and very quickly, in the Sherman case, Miss Sherman worked for the school district of the city of Los Angeles. She was completely asymptomatic when she suffered an industrial injury to her upper extremities, her lower extremities. And what happened was, after she reported an industrial injury, she was found to have rheumatoid arthritis. Now, prior to the industrial injury, you could say that she had a pre-existing asymptomatic rheumatoid arthritis. She had no evidence of the disease, but it was the industrial injury that lit up the quiescent rheumatoid arthritis. Well, the agreed medical evaluator opined that Miss Sherman qualified for 98% permanent disability without apportionment. Without apportionment. So, of course, the defense barked at that and contested that, and they wanted some apportionment due to the rheumatoid arthritis. They opined that a 98% whole person impairment rating was unreasonable, was outlandish, and was not an accurate description of her permanent impairment as a result of the industrial injury. They wanted some apportionment to the rheumatoid arthritis. Defendant contends that to the extent applicant's disability excuse me, is related to rheumatoid arthritis, it is not industrial. It is not industrial. Makes sense. They wanted some apportionment to the rheumatoid arthritis. The workers' comp judge the workers' comp judge stated that the medical opinion of the agreed medical evaluator justifies the finding that applicant's injury was proximately caused by her employment. That is, the agreed medical evaluator opined that although applicant's trauma did not cause the rheumatoid arthritis, it lit up the disease, allowing it to emerge and to be diagnosed. Therefore, the work comp judge correctly found that the rheumatoid arthritis was proximately caused by the employment trauma. The rheumatoid arthritis was proximately caused by the workplace trauma. Isn't that incredible? Due to the repetitive motions and what have you, Mrs. Sherman became symptomatic. She was diagnosed with rheumatoid arthritis, and he opined that the rheumatoid arthritis was proximately caused by the employment trauma. So, okay, so then what about the apportionment? The agreed medical evaluator stated that although the employment trauma did not cause the rheumatoid arthritis, it lit the disease up, that the applicant had no illness recognizable as rheumatoid arthritis and no disability in her joints before the employment trauma, that the work restrictions offered by him were caused by the rheumatoid arthritis, and that apportionment is entirely industrial. 100% of the permanent impairment or disability was 100% related to the industrial injury. The workers' comp judge states that under these circumstances, we conclude that the AME's opinion, as expressed in his report, established that it is medically reasonably probable, although not scientifically certain, that the permanent disability attributable to applicant's rheumatoid arthritis is not subject to apportionment under Section 4663. The agreed medical evaluator made the call. He made what seems to be a bold call that not one single percent of the resulting disability is due in any way to a pre-existing asymptomatic condition that was lit up by the industrial exposure. And because the workers' compensation judge found the opinion to be substantial medical evidence, he upheld it. He upheld the no apportionment opinion of the agreed medical evaluator. Now, in your opinion, is this a case, this rheumatoid arthritis case, is this a case wherein you may provide for some apportionment of the permanent impairment? It would make sense that some of the permanent impairment could be due to the rheumatoid arthritis, correct? But he went out on a limb and made a bold statement that 100% of the permanent disability was due solely to the industrial injury, and he supported it with substantial medical evidence, and it was upheld. Now, on the other hand, the Milivojevic case, Milivojevic versus United Airlines, shows just the opposite. In the Milivojevic case, the Workers' Compensation Appeals judge found that the agreed medical evaluator's opinion did not justify apportionment. So in this case, Mr. Milivojevic suffered a stroke on the job. He was found to have 91% permanent disability, 91%. Well, some years later, he was reevaluated for new and further worsening. And based upon the second evaluation, he was found to have like 100% permanent impairment. So it went from 91 to 100%. Well, it was also found that Mr. Milivojevic had high cholesterol. So the agreed medical evaluator apportioned some of the permanent impairment to the high cholesterol, a pre-existing risk factor, a pre-existing condition that would predispose this type of a person to this type of an injury. He provided some apportionment for the high cholesterol. In that case, the applicant sought reconsideration. The applicant disputed that opinion. The applicant, Mr. Milivojevic, and his applicant attorney. They believed that the high cholesterol should not be subject to apportionment. So the applicant sought reconsideration, contending in relevant part that the workers' compensation judge erred in apportioning any of his increased permanent disability to non-industrial factors because the AME, his opinion did not constitute substantial evidence to justify apportionment. The applicant used the argument that the agreed medical evaluator's opinion was not substantial. The agreed medical evaluator did not properly support his opinion and conclusion for the apportionment, and they sought a reconsideration of the opinion. And the defendant argues that 40% apportionment to non-industrial factors, meaning the high cholesterol, should be applied to the 2004 award of 91% permanent disability, not just the additional worsening permanent disability from 91 to 100. They wanted it applied to the whole award. Well, the judge found that on appeal, what they found was that there was no substantial evidence to justify apportionment of applicants' permanent disability, and based on that, they issued an award of 100% permanent disability. So this is very interesting. The agreed medical evaluator took the permanent impairment and he reduced it on the basis of high cholesterol. And he said that 60% of the final permanent, of the whole person impairment was due to the industrial injury, 40% was due to other factors in the form of high cholesterol. So without a substantial opinion, what is the only option of the workers' compensation judge? What the workers' compensation judge said in this case was that the defendant failed to prove the apportionment, failed to provide an opinion that qualified as substantial evidence, failed to support the apportionment. So what's the recourse of the workers' compensation judge? Is to disallow that opinion or conclusion and provide for the entirety of the permanent impairment. And in this case, they provided Mr. Milivojevic 100% permanent impairment. So you can see that if your opinion or conclusion does not qualify as substantial evidence, that opinion or conclusion gets cast aside. And at least as regards to apportionment of the permanent impairment, they provide the applicant with the full extent of the permanent impairment. So if you believe the permanent impairment is due even in part to other factors, you have to properly support that. Otherwise, the applicant gets the entirety of the permanent impairment rating. And it would go the other way as well. If you believe that the applicant, the entirety of the industrial injury, entirety of the permanent impairment is due to the industrial injury, but there are other factors involved, if your opinion does not qualify as substantial medical evidence, that opinion could be cast aside and the apportionment to other factors could be applied, even if that's not what you intended. So the point is, you can make the call. In this case, the applicant, the agreed medical evaluator, he made the call. He made the call to apportion out some of this permanent impairment to high cholesterol, but it wasn't upheld because the opinion and conclusion was not substantial medical evidence. And then finally, I want to share with you a little bit about the Benson case. And you may have heard about the Benson case. Sometimes in our cover letters we get a request to provide a Benson analysis on some of our permanent impairment ratings. And very briefly, the philosophy behind the Benson case is that when we had the passage of Senate Bill 899 in 2004, 1964. The purpose of passing Senate Bill 899 was to radically change the workers' compensation system due to skyrocketing workers' compensation system costs. And so the philosophy of Senate Bill 899 was to dramatically cut costs. And one of the ways that they dramatically did cut costs was they changed the apportionment and the causation regime. And they adopted new labor codes that govern the apportionment process. That was Labor Code 4663 and Labor Code 4664. Well, prior to the passage of Senate Bill 899, in the unique circumstance of an injured worker who had 2 industrial injuries to the same body part, when those 2 industrial injuries to the same body part became permanent and stationary at the same time, the permanent impairment rating for those 2 injuries resulted in a combined award for permanent disability, permanent impairment or permanent disability. The permanent disabilities of those 2 body parts were combined. And this resulted in very high monetary settlements for injured workers. Well, one of the changes wrought by Senate Bill 899 was that in the same unique circumstance where 2 industrial injuries were found to be permanent and stationary at the same time, those 2 injuries were rated separately. So, for example, prior to the passage of Senate Bill 899, in the case of Benson, Mrs. Benson received a 62% permanent disability rating. Well, after the passage of Senate Bill 899, she would receive 2 separate ratings, each of 31%. 31 and 31 is 62. Well, what's the difference? The difference is that a combined award for permanent disability is much greater than 2 smaller awards. And let me give you the numbers. Let me give you some numbers. Okay, let me give you some numbers. It says here, in successive injury cases, a single combined award of permanent disability is dramatically more costly than 2 separate smaller awards. And let me explain this to you. It says, this is because the permanent disability compensation schedule is progressive in that the number of weeks of indemnity payments increases exponentially in proportion to the percentage of the disability. Further, the maximum weekly dollar rate of payment now also increases with higher levels of permanent disability. The net effect of the increased weeks and increased rate of payments means that a single non-apportioned award of permanent disability indemnity is always higher, and sometimes considerably higher, than 2 separate apportioned awards. This is particularly true if the single non-apportioned award is 70% or greater, thereby also resulting in a life pension. Here, for example, in the case of Ms. Benson, although applicant's weekly rate of permanent disability payments is the same, whether she receives a single 62% permanent disability award or 2 31% permanent disability awards, the overall amount of permanent disability payments she would receive are significantly different. This is fascinating. That is, a single award, a combined award of indemnity for 62% permanent disability would total $67,000 payable at $185 per week for 362 weeks. However, 2 separate awards of 31% permanent disability would total $49,000. $67,000 for a 62% combined award, $49,000 for 2 awards, each of 31%. So Senate Bill 899 now, with the new apportionment regime in place designed to cut costs, requires that we consider each injury and the permanent impairment associated with each injury separately, which, as you can see, dramatically reduces the indemnity payments. But guess what? Guess what? There is an out clause on this. Okay, so there's an out clause in this. It says here that we're supposed to provide for permanent impairment ratings for each separate injury when those injuries occurred to the same body part and became permanent and stationary at the same time. But you could see that there are some inherent potential difficulties with that. That could involve some speculation, maybe even impossible to do. For example, if you evaluate the examinee after both injuries have occurred, how are you going to apportion permanent disability to one versus the other? It would be great if we saw the examinee between injuries, which would make it easier. But in some cases, it's not always possible to evaluate each injury separately, in which case the injuries can be evaluated in a combined manner. So the out clause says here, says that sometimes, any attempt by a physician to allocate the combined disability between multiple injuries may be impossible or inequitable and is likely to be no more than speculation or guesswork. And doctors, this provides the whole basis for the multiple dates of injury claims that you're seeing. How many of your recent cases have been a specific incident of injury on X date with a cumulative trauma injury leading up to that specific date? That's exactly the scenario that happened with Ms. Benson. She had a specific incident of injury and a cumulative trauma injury leading up to the specific incident. If the applicant can show that determining the exact percentages of permanent impairment due to each of those injuries is impossible, inequitable, and no more than speculation or guesswork, they can argue for a combined award, which, as we said, results in significantly higher, greater indemnity payments. So you, as the qualified medical evaluator, have the authority to make this decision in this unique circumstance where you have two injuries to the same body part, both of which become permanent and stationary at the same time. You can provide for a combined award and dramatically affect the outcome of the case if it's your opinion, and if you can demonstrate that your opinion is substantial. If it's your opinion that it's impossible or impractical or inequitable to consider each injury separately, you can then provide for a combined award rather than two separate, smaller, but equivalent individual awards. So, very interesting. Doctors, let's bring today's program to a close and simply review today's principles. And that is, in the workers' compensation system and as qualified medical evaluators, we have tremendous authority to dictate the direction of the case and the claim. We have that authority as the medical evaluators. We can call them as we see them, we can call it like it is, or we can call it any way we want to call it, and we can call it any way we want to call it as long as our opinions and conclusions qualify as substantial medical evidence. If they don't qualify as substantial medical evidence, as we've seen in the Milivojevic case, those opinions and conclusions will not be upheld. So always focus on the substantiability of your opinions and conclusions, and support each and every conclusion in your report with the how and why reasoning and the reasoning behind your opinions and conclusions, and you can never go wrong. So doctors, I hope this helps you, and I hope this gives you new enthusiasm for the work that we do. I look forward to being with you next week when we begin part 8 of this 10-part series. For now, this is Dr. Perry Carpenter, and I'm wishing you best of success in your career as a qualified medical evaluator.